Friends, we welcome you to the Legal Breeze. Today, we would like to discuss about an important happening, a milestone in the legal history relating to AI. For the first time, the international community has successfully adopted an international convention relating to AI. So we would like to discuss about it, what is its impact in India, how it will be beneficial to the human rights, democracy and rule of law, and what are all its overall advantages and disadvantages. All these things will be discussed in this particular video is concerned. First, let me tell you, this is the first ever official international law relating international legal instrument relating to AI. It is an authoritative one, authenticated one. It's binding upon all the members. But though the treaty has been adopted by the regional organization called EU, but it goes beyond EU because non-EU members are also participated, signed and ratified. So currently, around 50 plus members are there in this particular union, but it is expected to pick up in the near future and it may become a formidable force in the international arena to regulate AI and to combat adverse impact arising out of AI, particularly on the human rights, including privacy, data protection, surveillance, etc. So let us analyze the salient features of this AI treaty is concerned. As I have told you, it is done by EU. It is applicable to all the EU members and other members such as US, Canada, Japan. Japan is the only Asian member as on date which has signed as well as ratified this particular treaty. So other members, UK, they have also joined this particular treaty is concerned. This is an important one. It contains 8 chapters and the preamble and totally 36 articles, out of which the students are expected to remember up to Article 26, which is dealing with the substantial as well as procedural aspects of AI, its impact on human rights, democracy, rule of law, and international governance framework on AI, how to regulate AI, in which sector the AI should be used, in which sector AI should be restricted, in which sector AI should be completely banned. All other things have been discussed under this particular treaty is concerned. First, let us have a look on the preamble. It has a very long preamble, but broadly, this preamble can be divided into two major aspects. The first part of the preamble is dealing with the technological development relating to AI and its impact, both positivity as well as negativity, upon the enjoyment of human rights, democracy, and rule of law. How to mitigate it, how to overcome the adversity, how to promote the positivity. These things are addressed in the first part of the preamble. Second part of the preamble is dealing with this relationship between these AI treaty, AI technology, techno legal solution they call it, and its impact on the international human rights framework, including international humanitarian law. It refers series of international treaties and conventions relating to human rights, including UDHR, the two covenants such as the ICCPR, ICSR, and it also refers the CRC, the Child Rights Convention, CRPD, the Convention on the Rights of Persons with a Disability, and other human rights instruments which have direct relationship with the AI governance framework treaty and its impact, all these things discussed. So apart from that, it also discusses the advantages as well as disadvantages and how to mitigate the disadvantage, how to overcome the disadvantage. Certain measures have also been put in place by this particular treaty, and the preamble gives the roadmap for this. Please remember, whatever said in the preamble, either there is a specific chapter devoted in the main parts of the treaty or specific articles have been devoted to address each and every issue addressed in the or embedded in the preamble of this particular treaty. Now let us go to the chapters, main part of the treaty. The treaty has, as I have told you, 8 chapters. First 2 chapters are general in nature, dealing with purpose, definition, scope, etc. General obligations, all these things. Okay, chapter 3 is very important because it is dealing with the principles relating to AI, which has been already outlined in the OECD guidelines. I think I have already given a video in the form of charts to you. Please look at it, that also. Now let us look at the purposes. The purpose, as I have told you, is to regulate AI and promote AI only for good governance and prevent its abuse and misuse it. How it is done? It is done through a dedicated mechanism, both domestic as well as international mechanism, which is being set up by this particular treaty is concerned. It includes even regulates research and development relating to AI, how one should do research in AI, how the regulatory mechanism should function, what are all the AI products and services should get approval, monitoring mechanism. It addresses throughout the life cycle of the AI, though it doesn't define the life cycle of AI, but it has been explained in the preamble as well as the certain articles such as deployment, training stage, deployment stage, operation stage, and decommissioning of the AI system. So this is the AI life cycle, stakeholders of AI, many things, but it should be inferred. All these things have been defined in the OECD guidelines, and that could have been used by this treaty instead of repeating the same. It also defines under Article 2, it defines the term AI. It contains 2 parts. Typically, it adopts from the OECD guidelines. AI means it's a machine based system. Okay, it infers from the input for explicit or implicit objectives, from the input what it receives. Based on that input what it receives, it delivers the output in the form of recommendations, decisions, suggestions, and other predictions, which will have certain impact on the physical as well as virtual environment. This is very, very important. And after that, it has one more class. It simply states after the deployment, many AI system will develop its own autonomy in the decision making process. So that is also addressed in this particular point of particular part of the definition is concerned. As I have told you, it is typically adopting the OECD definition, which is dealing with the AI is concerned. Next one, it covers the scope and applicability of this convention. The convention positively covers all human rights, democracy, and rule of law, including privacy, data protection, surveillance, anti surveillance mechanism, all other things. Next one, it exempts certain things. Anything which is dealing with national security and the national defense is exempted from the operation of this particular treaty. Please remember the term national security has not been defined, but a limited exemption is given to the national security relating to AI usage, but it should be consistent with national as well as international laws. This is very important. However, a blanket exemption has been given to the national defense. So, this is the application and scope of this convention. Against whom this convention will be applicable? It will be applicable for all the states, including the federational unit, central government, state government, local authorities, all the things. And it goes one step further for all the public authorities and the private actors who are acting on behalf of the public authorities. And it differentiates between private actors acting on behalf of public authorities and private actors acting independently from the public authorities. All these entities are covered under the operation of this particular treaty. This is very, very important. Then this treaty goes up, setting up of certain principles or obligations such as protection and integrity of democracy, rule of law, independence of judiciary, separation of powers. All other things are also addressed in this particular treaty is concerned. Next come Article 7 to 13 is very important. It's dealing with principles pertaining to AI, which I have told you derived from the OECD guidelines once again. First, human dignity and individual autonomy should be preserved. So, AI should be used only to protect human dignity and individual autonomy and advance the human rights in this aspect is concerned. Next one is transparency and accountability. There shall be a transparent mechanism which is available, which is explaining on what basis the decision has been taken and what basis the conclusion has been arrived. All other things, if there is any breach, who is accountable, all these things shall be explained in a transparent manner. Then accountability and responsibility. This is very, very important. In this, there is something called how to identify the authentication of the content, or whether the content has been developed by AI system. If so, from where it originates, who is responsible for developing this content. All these things, certain mechanism, institutional mechanism, this treaty is addressing and fixes the responsibility upon the developers of malicious AI products and services, its adverse impact, its harmful uses, all these things. So, this is very important. Then it deals with privacy and data protection, Article 11. Uh, Article 10 deals with equality and non discrimination. This is very, very important. These are all protecting individuals' rights specifically. And Article 12 is dealing with reliability and responsibility and trustworthiness. This is also, again, we have explained you in the OECD guidelines. To what extent AI products are reliable, it should be certified this is reliable, and trustworthiness throughout the life cycle. Okay, that is very, very important. So it is dealing with the consumer protection along with human rights and other things. Then Article 13 deals with safe innovation. So innovation, yes, the innovation should be responsive innovation, safe innovation. Only innovations which are inventions which is protecting the human rights, promoting the human rights shall be allowed, and which is creating adverse impact shall not be allowed. That's very, very important. Again, it is also giving how to carry out these inventions, how to test those inventions before it is getting marketing approval. So, controlled environment, sandbox environment, they call it. All other mechanisms have been suggested before it is being rolled out to the general usage. This is very, very important. And next one is dealing with remedies and justice. So all these things done after all these rigorous tests, if an AI product has been put in place, but even after that, if there is any breach occurs or violation of human rights occurs, what should we do? So there shall be remedies must be available. The remedies must be accessible, affordable, and speedy and reliable immediately. This is very, very important. This is guaranteed under Article 14 is concerned. Article 14 is offering you substantive remedy like our writ jurisdiction. Okay, Article 15 gives you the procedural safeguards. This is very, very important. When there is a remedy, if there is a rate, how to file the rate, okay, what is the limitation period, all these things. The same way, what we have CPC, CRPC, that there shall be procedural safeguards. Okay, when you are filing the complaint, okay, identification of the victim, confidentiality of victim, confidentiality of complainant, how the complaint shall be addressed. All these procedural safeguards have been put in place by Article 15 is concerned. Next one is very, very important, Article 16. You would have heard something about called environmental impact assessment. The same way, AI impact assessment is mandated including identifying risk, prevention of risk, mitigation of risk is also suggested or mandated under this particular article is concerned. The next chapter is also very important. It's dealing with the implementation, how it should be implemented nationally and internationally. The implementation has to be secured without affecting the rights of the individuals, society, environment, etc. Okay, that should address including fulfillment of sustainable goals. This is very important. This is outlined in the preamble as well as in these particular articles. It also takes care specifically about women, girls, children, disability, and other people who are subjected to vulnerability. So a specific article has been devoted under Article 18 of this particular convention is concerned. Article 20 is very important. There are certain measures which is empowering the individuals, including developing skills, digital literacy, and training of personnel involved in this particular field, holding public consultations, public informed choices. All other things are mandated under this particular chapter is concerned. Then we have a monitoring framework or follow-up mechanism, that is chapter 7. So we have the conference of parties as the highest decision-making body, which will have a role to play, including countries have to submit reports to the COP, and the COP will devise its own procedure of functioning after the commencement of this treaty. International cooperation is also suggested in this particular treaty. In fact, it's not suggested; it is established under this particular treaty. Including international cooperation is feasible among the non-members of this treaty. If there is any member country or non-member country is indulging in abusing and misusing of AI, then this treaty authorizes to take effective actions against those erring states or violators through deterrent actions. So, how it is going to happen? Let us wait and see. This is very, very important. And thereafter, including dispute settlement mechanism, it doesn't specifically state like this is the mechanism, like you have an ICJ, that sort of body, but it gives a very flexible mechanism that we understand it can be done through interpretation, negotiations, arbitrations, and if necessary they can go for a tribunal as per their understanding. So these are all certain important measures given under this particular treaty is concerned. Thereafter, chapter 8 deals with final provisions like amendment, reservation, withdrawal, denunciation, notification of this treaty to the member countries, non-member countries, international entities, all other things, administration of the funds which is meant for these member countries as well as non-member countries of EU, their interrelationship and intra-relationship, all other things are addressed. Please remember, India has already adopted in its guidelines certain principles and mechanism which is embedded in this EU treaty. Example, the content authentication method, which has been suggested in this treaty, has been rightly adopted in the recent AI guidelines. Thank you.